Thank you very much, Mr. President. We were asked repeatedly about our policy about death penalty and also treatment in penal institutions and post-detention facilities, including Daiyo Kangoku. So, and also we were asked about our refugee policy. So now I'd like to invite the representative of Ministry of Justice, then the representative of National Police Agency, and again the representative of Ministry of Justice Immigration Bureau to answer these questions.
Now
I would like to answer how the prison in this law is being treated. So we will secure the body of that inmate, and we have to make a measure so that they are able to have the emotional stable stage. So for the notification of the death penalty will be given on the very same day in advance of the execution for some time. And if we notify them well advance, that will harm their psychological stability and gives more damage to their emotions and feelings, so that our current procedure is reasonable. And next, I would like to respond to the existence of the death penalty itself. For the idea, is already presented in the opening speech. So for small thing, to respond to the question from the Portugal, you mentioned that the number of the death execution in 2007, but unfortunately, we don't have the statistic number, so I cannot respond to the increase or decrease of the number from 1980. And there was a remark about the moratorium, the death penalty. It was already mentioned in the initial speech. But for the resolution, UN did resolution on the moratorium. Well, when the execution is once suspended, and then after that it is commenced, that is very cruel, because we gave the expectation to the inmate that execution would not take place, and then after that, again, they have to know they are going to be executed. That's very cruel, isn't it? And also the imprisonment without any parole. There was a reference about the pardon or parole without imprisonment. However, there is for the imprisonment without parole, meaning they are imprisoned for their life. That is they have the possibility to destroy their personal character, and that is very cruel and problematic as far as we understand now. So for the introduction of such a system, we have to consider very carefully. And also, from many countries, we received a question that we have a very high rate of conviction, and there is some miscarriage of the justice in the trial, and that problem was mentioned by some delegations. However, the conviction rate in Japan is the aggregate result of the judgment given by each court of law. So we are not in a position to respond to that as a government. However, our penal system, the procedure, criminal procedure of Japan is based on the very strict enforcement of implementation of the law. And I am sure we are just abiding by that law and implementing that precisely. So we don't consider it's abnormal that we have so high conviction rate. And under the three-tier level trial system, the application of the death penalty is done in a very cautious way. So we never consider, because of the high conviction rate, we have the possibility of any miscarriage of the judgment of the justice in the court of law, so that we conclude that we don't feel it necessary to consider the introduction of the moratorium because of the high conviction rate of Japan. And for the Daitai Kangoku system, or the substitute detention system, well, the purpose of this was already mentioned in opening remark, but I want to confirm that most of the suspects were not arrested, meaning that their body would not be arrested. And without being detained, they are proceeded to the trial. That is a system taking place in Japan. I hope you sincerely understand that. On the basis of that understanding, the criminal procedural law in Japan has the presumption of innocence and the right to appoint the attorneys, and also the right of silence are well guaranteed. And the guaranteeing of those rights is whether they are detained in the detention houses, facility, or penal institution. It is not relevant to that, whether they are where they are. And also, in the process of interrogation or investigation, some question mentioned about a recording or videotaping of the investigation or interrogation or monitoring. Because of the practicality of the exercising of the investigation, the statement by the suspect is very important in order to elucidate the truth of the case. So for all the process of recording, to make it a mandate to videotape and record the process sometimes hampers the relation between the investigator and the criminal, and also it will serve to stop the suspect to tell the truth. As a result, we are not able to elucidate the truth of the case. And to collect the information about the organization of the crime concerned, and also sometimes it goes the problem into the inquiry or into the true story behind the case. So we need a careful consideration about the introduction of such a monitoring or videotaping. I'd like to answer for the penal substitution system. I'm fully aware there is a criticism against the substitute detention system of Japan. However, in the detention facilities, the detention officer would not discriminate the Japanese detainees and foreign detainees, paying due attention to the protection of the human right of all those detainees or inmates. And we have revised some of the system of this detention system recently, so that we could have more guaranteeing towards the human right of those inmates or detainees. Thereby, the substitute detention system itself would not lead to the coerced or compelled confession on the part of the suspect. But again, we'd like to make a further effort for the improvement of the system itself.